You're someone with a vision for your practice, for your side hustle, and for your personal journey. But when it comes to establishing your path on how to get to where you want to be with your practice, things get a little messy. You're also someone who'd prefer to go in person instead of to groups and listening to everyone else's story. To me, it sounds like you could benefit from one on one consulting with our experienced practice of the practice consultants. From $5.95 a month and up, you can work with a consultant that will give you more direction and practical, tried and tested tips matched to you and your goals. For more information, visit practiceofthepractice.com/apply. Again, that's practiceofthepractice.com/apply. This is the Practice of the Practice podcast with Joe Sanok, session number 967. I'm Joe Sanok, your host, and welcome to the Practice of the Practice podcast. I hope you are doing amazing today. Memberships are open in Next Level Practice, our membership program for solo practice owners, Group Practice Launch, which is for people starting a group practice, and Group Practice Boss. Those memberships actually close tomorrow. So make sure you head on over to practiceofthepractice.com/level up to read more about those memberships. We open those up twice a year. We just did Level Up Week last week, and we have memberships open now. So make sure you read all about that, sign up for the memberships, and jump in if that's a fit, if you want to be around other people that are at your level. We do a weekly meeting with each of those programs. And so Group Practice Boss actually gets to go to 3 hours a week of training if they want. Most of them come to 1 or 2 hours a week. And so we have, over 12 live things we're doing every single month to help people grow in their private practices. So if that sounds good to you, if you want to join our membership, head on over to practiceofthepractice.com/level up. When I had my private practice, I remember that I had this one client, and they had like a hit and run thing happen where they had accidentally killed somebody. And it was a really extreme case, and the kid was coming to me. He was I think 17 or so, and they weren't from my area, so I'm not disclosing anything confidential in that, but they had come from a different state specifically to work with me. But it became very clear that it wasn't just for his own trauma that he was dealing with. It was that they wanted me to be an expert witness, basically saying that this kid was a good kid, and I had only worked with him for like 4 sessions. And it was this big legal predicament for me, where I ended up consulting with my attorney and talking through things. And he basically said, like, if you go and you testify as an expert witness in this area and you're not an expert, like that could ruin any future expert witness things. And he gave me all this really good advice where I basically told the family, like, I can be the therapist, and if you subpoena me, I'm not going to be able to say a whole lot other than just what we talked about in here. I'm not going to be able to speculate and probably help your case much. And it was just I was early in my career, I was freaking out, but by talking to my attorney to really sort through it, it felt like I at least had a framework. And that's why I'm so excited today to have Dr. Tracy Masiello, who is a licensed mental health counselor, supervisor, has a PhD, certified mediator in superior and district court cases, and court-appointed parenting coordinator in district and family court. Also a recognized expert in areas of where counseling intersects with the law. She's going to share knowledge as a provider of continuing law education for attorneys and judges, and by training therapists on court processes as an NBCC approved continuing ed provider. Tracy, welcome to the Practice of the Practice podcast.
Thank you so much for having me. I'm really excited to be here.
Yeah, well, I mean, this is an area, as I said in the intro, that so many therapists just freak out, and rightfully so. Like, we want to respect the courts. We don't want to get in trouble. We don't want extra lawsuits. We want to support our clients. So let's just start with, how did you get interested in this intersection of the law and therapy?
Basically, because years ago when I started my own private practice, and I've been doing this for about 25 years now, I am that old, I got subpoenaed. And I went to court and I wasn't prepared. I thought I was prepared. I read through the case notes. I showed up and I discovered that I knew absolutely nothing about really how the legal system worked or what to do or say. And I left the stand that day just feeling so defeated and worried. What did I say? Should I not have said this? Is there something else I should have said? So that really began my journey of trying to understand the legal process and what to do, because I kept seeing a number of clients who would come in and they would have reasons for wanting me to testify. I dealt with children of high conflict divorced parents who were having custody battles. I worked with some of the clients who were court appointed into therapy. So it kept coming up. And I decided that since I had to go, I might as well be good at it. So I really took time to train and learn everything that I could about the law. I actually took a lot of courses, and then my work as a mediator and as a court-appointed parenting coordinator also helped as well, because I had to have a lot of legal education and training in that area in order to do those roles. So that was how it started, and I've been doing this for a long time. I've had countless numbers of subpoenas, and I have trained at this point and consulted with countless therapists who get that subpoena and have that panic moment of, oh no, what do I do now?
Yeah, let's start with some just like basic terminology. So, subpoena, expert witness, fact witness. Take us through just what's the working terminology that we need to all be on the same page as we have this conversation.
All right, let's first just talk about what is a subpoena, and why does it matter if you respond to it or not. Really, a subpoena is just a legal request. It's asking a clinician to either provide testimony, records, or both for a legal proceeding. And there's this common misconception out there among many in the therapy world that a subpoena from a judge is a must answer court order, while one from an attorney can be ignored. But the truth is, ignoring a valid subpoena, whether it's judge or attorney signed, can lead to fines or even to jail time.
Mm,
So even if it's an attorney subpoena, a therapist should not dismiss it. In fact, there are some states, like Michigan, for example, where an attorney signed subpoena has the same exact weight as one that's signed by a judge. So ignoring it is going to lead to the exact same types of contempt charges, which again can be fines or even jail time. And therapists have gone to jail for ignoring subpoenas. And even if you aren't in one of those states, in most states, attorneys are able to do what's called filing a motion to compel that goes along with their subpoena. And if that's granted, it gives their subpoena the same weight as a court order. So again, if a therapist ignores that subpoena, they might not realize that there is a motion to compel there and that they're basically doing the same as violating a court order. And even if you don't have those extremes, it's really common for an attorney just to tell the judge, when they show up to the hearing, that a therapist didn't respond to that subpoena. And the judge has the discretion to give them sanctions because, again, it's just a legal request. Or they can just have the judge reissue it as a court order, which means that in the end, the therapist is ultimately still going to have to respond to it. But now that really reflects poorly on the therapist because they've wasted the court's time, the attorney's time, and they've probably cost their clients money because the clients are paying for those attorneys, only to have the same outcome. So therapists really should always respond to a valid subpoena, no matter who signed it. And I do
mm,
want to say here, I see therapists that I've coached a lot who will have policies that state they won't go to court if a client, agrees not to subpoena them. The policy says the clients will not subpoena them and they don't go to court. I see that a lot actually. And they kind of feel like they're hiding from that potential subpoena by having their client agree to this policy. But the reality is that those policies have absolutely no real weight. Therapists will still have to respond to a valid subpoena, whether the client agrees or not. So the client has that right to request their therapist testimony, and therapists cannot assert privilege if the client wants them to testify because privilege is actually owned by the client. It's not owned by the clinician.
mm.
So, what that means is that even if your client signs that agreement not to subpoena you and not to ask you to come to court, you still have to go if they subpoena you, right? That you can't decide as a therapist that you don't go to court. That things are privileged. That belongs to your client. So
Th-
what you can do though is talk with your client, about your role and talk to them about the pros and cons and what could happen. and how you testifying could benefit or harm them or the therapeutic relationship. So there's things that you can do to have open conversations with your client around that, but you can't just say I don't go to court policy and expect that to hold water.
Yeah. Now, do you recommend people have fees in their intake around what, getting paperwork for a subpoena, going to court, sitting in court, that sort of thing?
I absolutely do. And I also recommend that you have very high fees for that because it is common, especially if you work with, parents who are in custody battles, that they want the therapist to come in and testify pretty much at the drop of a hat. So we charge a minimum of $1,000 a day. Even if we just go to court for, even if we're there for a few minutes just to get on the stand, object to testify, and get off, they're still paying that $1,000, per
Mhm.
day. We charge, fees for prepping for court. We charge fees for reading our notes. If we talk with an attorney, prior to testimony, we charge for anything and everything, travel time, and we have high fees. And clients have that as part of our intake paperwork. They know that up front that these are the fees. And I absolutely 100% recommend that all therapists have these fees in their intake paperwork because that can help, prevent clients from subpoenaing you and just thinking that you're going to show up and testify. Instead, now they're probably only going to do that if they really feel like what you have is valid and important.
Hmm. Okay. And then when you say expert witness and fact witness, can you differentiate between those?
Yeah, there's a big difference between the two. If you're testifying as a fact witness, that means that you're going to talk about things you have directly heard or observed. Whereas an expert witness is going to talk about things based on their expertise about a matter and they can give their opinions. Now, if you're a clinician and you've been subpoenaed by your client, you are most likely going to be a fact witness. And you need to stay only in that role. So, as a fact witness, you never want to give your opinion or make any statements that are drawn from your expertise. You only stick to what you've seen or what you've heard. So, for example, you would not want to say something like, you know, Mr. Jones is emotionally abusive to his children, based on the fact that the children have told you about all of these behaviors that he's done, things he said that would, in your opinion, qualify as emotional abuse. Instead, you would say, the children have reported to me that Mr. Jones said X to them, Mr. Jones did X to them. So you're making it very clear that you are only reporting about what you've been told directly. You're not drawing any kind of interpretations or opinions about it. Or if let's say you saw Mr. Jones, saying these things or behaving in certain ways in the waiting room, that's what you would say. I observed Mr. Jones to say X, Y, or Z. But you would not want to say he's emotionally abusive.
Mm.
That would be giving an opinion or drawing a conclusion. An expert witness can do that, but you cannot do that as a fact witness. And that's an important distinction because if you're on the stand, it is often the case that attorneys will try to pull you into that role of expert witness. They want you to give their opinion about somebody's parenting or somebody's symptoms or their prognosis. They want you to talk about from your expertise, as somebody knowledgeable of the field, what does it mean if, a client has a certain diagnosis? Those are the things that you don't want to do when you are there as a fact witness. And it's okay and really even ethically required that you object to such questions and that you remind them that you were just there as a fact witness and can only testify about what you've directly seen or heard about that client.
Mm. So you had said originally that the client owns kind of the testimony. I forgot
Mhm.
how you said it exactly,
The
the
privilege, right?
privilege. Yeah. So the client owns the privilege. So how does that work if there's a therapist seeing children that are underage and there's, say two divorced parents and it's contentious? Can one parent object to, or do they have to agree? How does that work in that situation? Because I know a lot of therapists get in that muddied waters where, one parent wants to bring the child to therapy, the other doesn't, and then there can be subpoenas and all that messiness. Like, what should people know about specifically when they're seeing kids from parents that are divorced or not together?
You are absolutely right about that scenario, and it does come up frequently. So, anytime that you've been subpoenaed to testify or to share records, again, you always want to have that conversation with your client about it. Talk about the pros and cons, make sure that they understand the situation, and then ask for their consent, for their informed consent for you to testify or share those records. If both parents agree and they sign that consent form, then you can do that. But again, you only want to testify or share records that are exactly in the scope of what's in the subpoena and nothing more. You always want to give the most minimal amount that you can give while still complying with the subpoena. But let's say, like you mentioned, Joe, that one parent objects. In that case, even if the other parent gave you permission, you would have to object to the subpoena, right? You would still have to respond, but you might do something like object on the grounds that you don't have, both parents' consent. In that case, again, privilege belongs to the client. The client, in this case, because the child's a minor, are going to be the legal guardians. So if the legal guardians don't want you to testify, then you do need to object if you don't have the consent from both of them. And you would try to either then quash the subpoena, which means to vacate or terminate it, limit the scope. There's lots of different things you would do. But essentially, when you get to court, if you do have to go to court and testify, then the first thing you would want to do is to object to testifying on the grounds that you don't have that consent from the parents. And in that case, it's up to the judge whether or not the judge wants to compel you to testify or not. If the judge compels you, it's a court order, and now you have to do it, and you don't need to have both parents' consent. And it's on the record that you're not just giving this, from your own, based on your own decision. But sometimes, judges will, agree to not have you testify. I've had that happen many times. I've seen clinicians that I've coached who've had that happen. They get in, they object, and the judge releases them from the subpoena.
Mm. Now, talk about expert testimony.
So when you're an expert, you're basically called in now to give opinions, to give your knowledge based on your expertise. And as you mentioned in that example you gave at the start of the show, Joe, it is really important when you serve as an expert witness that you only testify about things within your scope of knowledge and scope of practice. And when you're an expert witness, there is a lot that goes into it. I recommend that anybody that wants to do that does get trained in how to do that, because there are certain protocols and procedures that you need to know in terms of how you do that, what you present, what kind of qualifications you need to have. But when you're an expert witness, you know that you're an expert witness, and you're usually going to be hired by one side. So typically it's not going to be both sides who want your opinion. That can happen, but it's not going to be as common. But you're usually going to be for the plaintiff or the defendant. So your testimony is going to be guided by what their goals and objectives are. So that's very different from being a fact witness, where you're just there to be a neutral third party and give objective testimony about what you've directly seen or heard or observed. Instead, as an expert witness, you are drawing conclusions. You might be interpreting, research literature and bringing up court cases and talking about how those apply to the matters at hand. So it's a very different role. And again, sometimes attorneys will blur those roles by asking you to talk about expert matters rather than just sticking to the facts that you know as the clinician in the case.
Hmm. As a therapist, I can tell you from experience that having the right EHR is an absolute lifeline. I recommend using therapy notes. They make billing, scheduling, note taking, telehealth, and e-prescribe incredibly easy. Best of all, they offer live telephone support that's available 7 days a week. You don't have to take my word for it. Do your own research and see for yourself. Therapy Notes is the #1 highest rated EHR system available today, with a 4.9 out of 5 stars on trustpilot.com and on Google. All you have to do is click the link below or type promo code Joe on their website over at therapynotes.com and receive a special 2-month trial absolutely free. Again, that's therapynotes.com, and use promo code Joe on the website. If you're coming from another EHR, Therapy Notes will also import your demographic data quick and easy at no cost, so you can get started right away. Trust me, don't waste any more of your time and try Therapy Notes. Just use promo code Joe at checkout. How important, if this is happening, is it to consult a local attorney to walk you through these things?
Absolutely, 100%. You should always do that. As soon as a subpoena hits your desk, there are really 4 steps, I would say, that a clinician should take. The first is to make sure that it's a valid subpoena. And what I mean by that is there are certain features that a subpoena needs to have in order to be valid. If it's not valid, you don't really need to take any steps or any action about it. So, for example, a valid subpoena has to be signed by the clerk of court, a judge, or an attorney. But I have seen cases where clients have tried to, DIY their subpoena and they signed it themselves to give to a clinician. So in that case, it's not a valid subpoena, and so there really is no further step to take. The next step is to make sure it was properly served. Again, there's certain rules of procedure around how you can serve a subpoena. And I have commonly seen clients who will show up to session and they hand their therapist a subpoena to come and testify about them or about their child, or they have their child bring the subpoena to the clinician. And a valid subpoena cannot be signed by a party to the case. So if your client is the one who's a party to the case in which you're getting that subpoena, they can't give it to you. A child cannot give it to you because the person has to be 18 or over. So again, if it's not properly served, it also is like it didn't happen, and you should still maybe respond to say that, but essentially you can ignore it and there's really nothing further for you to do. But assuming that it's valid and properly served, then your next step is always to contact your liability insurance carrier. Your premium pays for an attorney, so take advantage of that. You've already paid for it in essence. It's very rare that you would have any other fees incurred beyond that if it's a pretty open and shut situation. So since you have that insurance, contact them. They typically have a way, usually online, that you can just email or upload it, through their website portal, and they'll look at that subpoena, and they will assign an attorney to you. The couple of caveats I would give you to that, though, is to make sure that you do ask for an attorney in your state. A lot of these companies will have, a whole slew of therapists from different states who know mental health law, and they will assign you one from another state. But there are subtle differences sometimes from state to state, and I've seen cases where an attorney in one state has given a therapist in another state some advice that wasn't quite accurate for that therapist's own state, and it landed those therapists in a little bit of legal and ethical trouble. So ask for somebody who's from your state, and also make sure that they do know mental health law. Again, a lot of these big insurance companies have attorneys who are on hand who might know medical practice law, but they don't always know some of the nuances of mental health law. So make sure that you get somebody who has both of those in terms of their expertise and their experience.
Mhm.
And they will then consult with you and ask you what you want to do, and you have options when it comes to handling a subpoena. You can ask to vacate it, to quash it, and there's certain grounds for doing that. You can ask to have the scope of what it covers limited. You can ask to, instead of testifying or sharing records, that you be allowed to provide a treatment summary or a progress summary that's in written format, because there are ways that that can be entered into the record. So there's different options that you have. And so when you have that attorney, call, be prepared to know what you might want to suggest or what you might want to do. I think most therapists, our knee-jerk reaction is to say, just quash it. I don't want to show up. I don't want to have to share records. I don't want to deal with this. I just want you to make it go away. Because we're nervous, right? We're anxious about testifying or what might happen, especially if we haven't done this. But the reality is sometimes we have information that's helpful to our clients, right? And we never want to do something that could be harmful to them. And so if we let our own fear and anxiety prevent us from helping them and giving information that could be beneficial to them, then that also, runs an ethical risk there, right? Right. So we really want to respond and to show up and help our clients when we can, but there are ways that we can do that where we limit the scope or we just provide that summary.
Mhm.
So think about these things before you meet with that attorney, so you're kind of prepared about what you want to say when you have that conference call.
Yeah. Now, I'm thinking about how a lot of what we talked about is, say, post subpoena. We covered a couple things, kind of making sure that you're in a good state before you ever get subpoenaed. So, for example, we talked about the intake, making sure that you have language in there and fees in there. What other things for folks that are listening now that they may not get subpoenaed for years? What should they be doing now, though, to just make sure that legally they are sound if things were to happen.
Absolutely. It really comes down to what you share at intake, from day one. That is your first introduction that you give your client to your practice, or your policies. So have very specific policies in there about how you handle subpoenas, limits of confidentiality, what you require. Like, my policies state that I require a court order from a judge or one that, a subpoena that compels me to testify. So inform them up front what is expected, right? Make sure that you have very clear, very specific policies. Make sure that all of those fees are there, that they understand exactly, how much notice you need for a subpoena. My policies include that I have to have so many days notice before I'm asked to attend. Otherwise, the fees are doubled. It also states that if I'm on vacation, the fees are doubled. So if I have to give up my vacation to come to court for them. So anything that you want to have, make sure that you have that in writing in those policies and that all clients sign them, not just the ones where you think they might be likely to subpoena you because, maybe it is parents who have a high conflict divorce, or maybe it is a client who's been, court ordered to therapy and you anticipate that you might be called. Do this across the board for all of your clients and just make it a part of those intake documents. And also at the intake, talk through that, with everything else that you review of your policies with the client. Talk about that, talk about the pros and cons of subpoenaing you. Something that they might need to be aware of is that after you have been asked to testify, there is a chance that you might share things that your client didn't want you to share because you're compelled to, right? Once you're there, you lose some of the control over what happens, and it can damage that relationship. And it might make it so that you can no longer continue to be their therapist after they've asked you to testify. This happens a lot of times in custody battles. One parent may feel that you're aligned with the other parent if they didn't like how you testified on the stand. So talk through these things with your clients ahead of time, because oftentimes that may dissuade them from subpoenaing you if they don't really feel that it's necessary, right? Especially if they realize that they might have to find another therapist if they do that based on what happens in that testimony.
Mm.
So there's a lot of things you can do up front and just make them, across the board a part of your policies and procedures. We also have what's called a safe harbor agreement in my practice, and that is for those clients who have parents who are divorced, and it has basically policies around sharing notes with parents, around subpoenas, around testifying, um, so that the therapy space can be that safe harbor for children to feel safe and comfortable sharing. So we let parents know up front what that policy is about, why we have that policy, and we do ask them to sign it.
So many good things. Now, from a financial standpoint, and maybe you covered this and I missed it, do you have people pay upfront before you go into court, or do you wait until after to see the total billable hours, or is there like a retainer? How's the financial side work?
Typically, they have to give us the $1,000 for the first day of testifying, a minimum of 72 hours before the hearing, or we are to produce records or anything else. So we get the first $1,000 up front, and then we bill everything else. So
Mm.
travel time, court prep, everything else gets billed after that. If they need us for more than a day, then they get billed for the second day at the time of. But we do keep a credit card on file, and we do have their authorization to charge that card. And if they don't give us that money within that 72 hours, that gives us a window to essentially take some steps to either get that or to find out, if we can quash the subpoena or delay the hearing.
Mm. Wow, so many steps and such great practical information. If every private practitioner in the world were listening right now, what would you want them to know?
I would say again, just be proactive about this. Recognize the fact that it's not a matter of if you're going to get subpoenaed, it's more likely a matter of when. I know so many therapists who say, oh, my practice isn't the type, where we have clients that are likely to do that. I don't really need that. Or I've been doing this a long time and I haven't ever had that happen. You would be surprised as our society is becoming more litigious, about how much people are finding that they're being subpoenaed these days. And it's likely to happen. If you do this long enough and you see enough clients, it's likely to happen. So the more proactive and prepared that you are, the better you're going to fare when that happens. You're not going to freak out and not know what do I do and be stressed out. And that's important because when you're on the stand, when you're sharing records, when you're doing these things, there really are legal and ethical ramifications if you don't get it right. So the better prepared you are up front, the less you have to stress about it when the time comes.
And Dr. Tracy, if people want to follow your work, learn more about what you're doing, any resources you have, where can we send them?
Absolutely. If they want to go to the training arm of my private practice, which is called Resolution Academy, and the website is resolutionacademy.com, there is a link to a course that I have, which is everything you need to know about subpoenas, how to testify, all of those great things. It's called May It Please the Court, Subpoenas and Testimony for Clinicians. And in that link, you will find a free download for a checklist. It's called the What Do I Do Now checklist. And it really is designed to give you the steps of what to do the minute that subpoena lands on your desk and you have that moment of, oh no. It walks you through step by step what you need to do and what steps to take so that you can feel prepared and not be quite so anxious or so nervous about having that in your hands.
Mm, so awesome. Well, I hope people go check that out. Thank you so much for being on the show today.
Absolutely. I really appreciate you having me here and letting me talk about this. It's really important stuff because, again, we don't really get much training on this in grad school or beyond. And considering how likely it is that clinicians will face a subpoena or having to testify at some point, I really do appreciate you letting me share this information today.
Have a wonderful day.
Thanks, you do as well.
I love episodes like this where it's just so practical. The steps, to understand it. I remember I had this guy, Young Gi, who lived with us and he was learning English. He was from South Korea and stayed with us for a semester. He was a adult that moved to America through a program where he could just learn English. And I remember this one night that I was making stir fry and I was making rice just like on the stove. And he was shocked that I wasn't using a rice cooker. It just like blew him away. And he made this statement that has stuck with me, and it was, "It's easy when you know how." And I think so much of whether it's private practice or business is that we're just not informed. That we're worried that we're going to do something wrong on our taxes or with our bookkeeping or with legal requirements. And really, it's just a matter of learning some of these things, having good advisors that are experts in these areas, going through good trainings, all of that. And it's easy when you know how. So take the time to do those downloads. We'll have links to that in the show notes if you're driving or running or doing something like that. And make sure you join our membership communities. We have experts just like Dr. Tracy coming in once or twice a month into our communities to do deep dives, to ask questions and to dig into things. We have AI experts. We have big private practice experts. We have financial experts that we bring in for our membership communities. Remember, those membership communities are open right now. Those only open twice a year. You can read more over at practiceofthepractice.com/level up. It has all the information about all of our different membership communities that are open right now, no matter your phase of practice. We have over 30 e-courses you get access to. You get access to those meetings that we're doing, small groups, to help you just move forward faster. Also, we couldn't do this show without our amazing podcast sponsors. Therapy Notes is our sponsor for today's episode. If you are looking for a better EHR, if you are not with Therapy Notes, they will help you transfer over all of that data. They have integrated HIPAA-compliant video. They help with the billing to make insurance billing really easy. They're an amazing platform that you definitely want to try out. You can try it out totally for free for a few months over at therapynotes.com. Just use promo code Joe at checkout so that you can get that promo. And then also they know that this works to talk about you on the podcast. People are looking at how their advertising dollars are working. So please use promo code Joe at checkout. Thank you so much for letting me into your ears and into your brain. Have a great day. I'll talk to you soon. Special thanks to the band Silence is Sexy for that intro music, and this podcast is designed to provide accurate and authoritative information in regard to the subject matter covered. It is given with the understanding that neither the host, the producers, the publishers, or guests are rendering legal, accounting, clinical, or other professional information. If you want a professional, you should find one.